Hello, good afternoon, everyone. Welcome to the Silver Lining Charities June 2026 mid-month meeting. We're joined today by Hokman Wong, an associate from Bolt Burdon Kemp, who are one of our fantastic affiliated solicitors. And Hokman's going to speak to us today about returning to work after a brain injury. Thank you so much, Hokman. Welcome.
Okay, thank you, Louine, and thank you everyone for having me. Yeah, I'm going to talk about some common legal issues which arise when a person returns to work after a brain injury. I've prepared some slides which I'm happy to send to Louine and for him to share with everyone if you want a copy. But yeah, let me share my screen.
Hmm.
Okay, can everyone see the PowerPoint slide? Common legal issues returning to work after brain injury?
Thank you. Yes. Yeah.
Yeah. Okay. Okay, great. Okay, so just an introduction before we get started. Um, my name's Hokman Wong. I'm a specialist brain injuries solicitor at Bolt Burdon Kemp. Some of you will have seen me at the monthly meetings at our office, uh, uh, and I can see some familiar faces already. Yeah, so what I do is I help people who have suffered a brain injury obtain compensation. And what I'm going to do now is I'm going to give an overview of the law which relates to when a person returns to work after a brain injury. I should note that my specialism is litigation and obtaining compensation. So I'm just going to give just a broad overview of some employment law issues. Then once I've gone through some of the law, I'm going to talk about how the law might apply to real life situations. And if we have time, I will run through a few case studies from some of my cases where I have observed how a brain injury has affected a a person's ability to work. And as Louis mentioned, that this is going to be an open discussion. So please do ask questions and provide your thoughts and experiences as we
What
go
do you
along.
think about going back to work?
Uh, yes, that's right. So I'm going to go through various different topics, and at some points I'm going to specifically open things for discussion. But if you know, as I'm talking, you have any questions or you would like to share anything from your experiences, just please please just shout and just say what's on your mind. Right, and what I'm going to do is I'm going to talk about situations where a person is in work and they've suffered a brain injury and they're on sick leave and then they're thinking about going back to work. And I'm also going to talk about a situation where a person with a brain injury is out of work and they are looking for a job. So it's slightly different positions, but but they do converge. Okay, right. So, in terms of the structure of this talk, I'm going to very briefly touch upon state benefits because that does apply to people who are out of work. Then I'm going to talk about employment law and the protections that it gives. I should note that employment law doesn't apply to volunteers. So volunteers have less protection when it comes to their work. I'm going to then talk about employment law in practice, and again, I will talk about some real life examples from some of the cases that I've worked on. Okay, so starting with benefits, yeah, I'm just going to briefly touch upon this because it is relevant to to people who are in and out of work. Okay, you've got universal credit. The idea of this is to help people who are not able to work or are on a low income, and you can claim this even if you are working. Yeah. The way it works is if you are working for every £1 you earn, your universal credit payment goes down by 55p. And you apply for it online at the .gov website. And there are lots of free calculators online which can help you work out how much money you might be entitled to under universal credit. Okay, universal credit is means tested, which means the amount you get under it varies depending on how much money you have or the amount of money that you earn. And there's lots of different elements of universal credit. It's quite complicated, and I'm not going to go into every single one. Um, there is a standard allowance, and there is a work allowance if you have a disability. And I guess it's the work allowance which might be relevant to people with brain injuries. Yep, and you also have additional elements for children, childcare costs, and housing costs. The To give you an idea of how much you might get for universal credit, as of April 2026, if you are single, over 25, you don't have children, and you have a limited capability for work, i.e., the work allowance at a higher bracket, you could get £854 per month. Okay, the next benefit is PIP, personal independence payment. This isn't means tested, and it's to help with the extra costs of having a disability or long-term health condition. Um, and of course, you can claim this even if you're at work. Right, so to qualify, you have to be between 16 and 64 and have a long-term illness or disability. You apply for it by telephone. You can get the telephone number on the .gov website. There are two components to PIP with weekly rates, so you're paid each week. You have a living component, which is £76.70. If this is enhanced, it's £114. There's a mobility component. The standard amount is £30 and 30p, and the enhanced is £80. Right. Yeah. So as I mentioned, I'm not really going to go into benefits in much more detail, but there's lots of free advice and assistance available to help with applying and appealing decisions. Okay. So on to employment law issues, which is the main part of this talk. I'm going to talk about long-term leave and sick pay. I will talk about retirement on grounds of ill health, unfair dismissal, disability discrimination, and reasonable adjustments. So I think it's probably it's this section which is most relevant to brain injury survivors. Okay, sick pay. So if you're working and you suffer a brain injury and you have time off sick, and each employer will have their own policy on sick pay. You should find this in the employee handbook, and it might state something like they will pay you full pay for 3 months and then half pay, etc. But by law, employers must pay you a minimum amount when you're sick. This is known as statutory sick pay, and it's paid to employees and workers. Statutory sick pay is £123.25 per week, and it can be paid up to 28 weeks, which is half a year. So unfortunately, after half a year, if you're still on sick leave, your employer doesn't have to pay you anything. Okay. in terms of retirement on grounds of ill health, it is lawful to dismiss an employee due to an illness if they are unable to do their job. But even if this is the outcome, an employer has to follow the correct procedure, and if they don't, they may be in trouble, and we'll come on to this. Okay. Um, Now I'm going to talk about unfair dismissal. All right. It might be unfair dismissal if did someone want to raise something? No? Okay. Well, I'll carry on. It might be unfair dismissal if an employee who has worked for at least 2 years, so this is known as the qualifying period. So if you have worked for 2 years, you get protection under unfair dismissal laws. However, the qualifying period is going to change to 6 months from the 1st of January 2027. And it might be unfair dismissal if any of the following apply. If there was no fair reason for the dismissal, if the reason was not enough to justify dismissal, or if the employer did not follow the correct procedure. So why don't we have a little discussion? Could anyone think of what could be a fair reason for dismissing someone? Any
If they're
idea?
not attending work on time.
Uh, uh, yes, potentially. Yep, that's right. Would anyone else like to
Are employed to to use a particular skill, be it mental or physical, if they can no longer do it because they've
exactly?
lost that ability.
Yep.
So if you were
Yes.
driving previous drive, how would that work?
Yeah, exactly. Yeah, yeah, that's right. All of those would be fair reasons. So to give you an example, under the Employment Rights Act, some potentially fair reasons to dismiss someone would be misconduct. So that's when someone has done something that's inappropriate or not acceptable. Capability,
I don't know, yeah. It's not, Chris, it's not really up for you.
okay. Right. Another potentially fair reason to dismiss someone would be capability, which would be what Simon raised. You know, if you can't, if you can't, if you're not capable of doing the job.
But presumably, when that's subject to them having to make certain allowances.
Yes, that's right. And I'm going to go on to that. And I think what you mean by that is, was it reasonable adjustments? Are you
Yeah.
thinking?
Yeah.
Yes. Yep,
Thank
that's
you.
right. Yeah. Exactly. Reasonable adjustments is actually part of um, discrimination law, which I'm going to talk about next. But unfair dismissal is separate, and I guess, you know, and I guess, I mean, you know, an example of an unfair reason to dismiss someone is perhaps if someone wears a purple hat into the office and then the manager doesn't like that. That would be obviously unfair. Or if the reason was not enough to justify dismissal. So what happens if a person comes in late twice a week? As Louise pointed out, coming in late all the time could be potential maybe reason, but if you came in late twice a week, well, that's probably not enough to justify dismissal. And then finally, a very important part is
Sorry to interrupt there. Hello.
yes,
I'm Christian support worker. He's going to leave. He's sort of like just dropping off.
Okay.
Sure.
So we're just going to say our goodbyes. Sorry about that.
That's
No
okay.
worries.
Okay, bye.
Goodbye.
No.
Okay, and finally, it's very important that an employer
Yep.
follows a fair procedure, and if they don't follow a fair procedure, they could be in trouble, and they could have found to have unfairly dismissed someone. So even if there is a fair reason to dismiss someone, but the procedure that the employer follows has not been fair, they could be in trouble. Yeah. Okay. Um, would anyone like to share any thoughts about those things before I move on to the next section, or any of their own experiences?
Can you say something about a bit about the procedure? Because I think it can be quite long and drawn out, can't it? And
It
quite
can be.
detailed.
You are right. It can be, and actually quite rightly so, because I think dismissing someone is quite a big step, and you can't just do it lightly. You have to give the employee the procedure has to be fair to the employee. So, in terms of what is a fair procedure, you can find, well, employers have to follow the code of conduct and set up by ACAS, which is an organization which gives guidance on employment law issues. And the ACAS have their own website. It's spelled ACAS, if anyone's not heard of them. And they are great and they are a great source of free information on employment law issues. So, some of the principles that ACAS has set out in terms of a fair procedure is that, well, I can just mention some of these. That employers and employees should raise and deal with issues promptly. There shouldn't be delay. There should be meetings and then confirmation of the side of decisions after those meetings. Employers have to act consistently, so they have to apply the same procedure to everyone. It would be unfair if they applied a different procedure to different people. Employers need to carry out necessary investigations. They have to inform the employees of the basis of their problem, and they have to give employees an opportunity to put their case forward before decisions are made. And employers should give an option to appeal any decision. So I don't know if any of you have been involved in disciplinary procedures at work. Has anyone been through this process? I mean, if you have, you realize that, as Simon says, it is quite drawn out. But I think rightly so.
I've not been through it personally, but I went through a redundancy program at our firm, and all this sounds very similar to what all the criteria that had to be met to make someone redundant.
Yeah. I mean, the principles of fairness apply to
Yeah.
many different situations.
Hokman, just one thing. Is it always advisable to take a representative with you if you have meetings of this sort?
Oh, yes, it is. Yeah, that's right. And actually, I omitted to mention that whenever a person goes into a disciplinary hearing, they do have the right to have someone accompany them. And of course, if you're a member of a union, you would have a union representative, but it could be
Hokman, correct me if I'm wrong. Is it to have legal representative, or is it to have a colleague union representative at a disciplinary hearing?
You can have a union representative. I guess, well, if you are entitled to bring someone else in. I mean, if you're able to bring someone in who's legally trained, then I don't see why that person would be excluded.
Thank you, Hokman. Thank you.
Okay. Right. So now on to the Equality Act. So this is the act which covers the point that Simon made about reasonable adjustments, and reasonable adjustments comes from this. So I will get onto that. Okay. A good thing about the Equality Act is there's no qualifying period for there's no qualifying period for protection under this act. So you don't have to have worked for 2 years before you get protection under this. You have protection under the Equality Act straight away. The Equality Act lists protected characteristics, and it makes it unlawful to discriminate against anyone because of a protected characteristic. So let's have a quiz. Oh yes, and I should note that the Equality Act lists the protected characteristics. So let's have a quiz. Which one of these do you think is not protected? Age, political belief, being married, civil partnership, or gender reassignment?
All of them.
And anybody else? Which one is not a protected characteristic? Okay, well, the one that's not protected is political belief.
Ah,
Yeah.
Okay.
So if you're a member of the Monster Raving Loony Party, you can be discriminated against. Sorry.
we're all raving loonies here.
You have to be in politics.
Yes. Yeah, or just a narcissistic egomaniac. But anyway, not going to go into that.
Please don't.
Okay, another one. Which one of the following is not protected? Pregnant, maternity leave, race, religion, or medical condition?
What are you saying, Al? Religion.
Religion is
I would think they're all protected in some way.
Okay, well, this was a bit of a trick question. It was a lawyer's trick question. Where I was just playing on words. I mean, okay, so having a medical condition is not per se a protected characteristic, because I mean, what is the medical condition? Just that's right. So yeah. Okay. And then finally the last one. Which one of these is not
Oh, Al, you're so
protected?
funny.
Number 4.
Number 4.
Yes, that's right. So if you are just annoying at work, unfortunately, you can be discriminated against. So yeah, I guess the point of this last one is that disability is a protected characteristic, and disability is most relevant to people with a brain injury. So you will be disabled under the Equality Act if you have a physical or mental impairment that has a substantial and long-term negative effect on your ability to go about your business.
Does it define negative effect?
No, but it's kind of taken in its everyday understanding. So it's not that there's not that much to it, but you
So
would need
Hokman, it could just be a little tiny negative effect. It doesn't have to be an inability. It could just be a nuance thing.
Well, it has to be substantial and long term. Long term is usually more than 12 months.
Right.
But substantial, that's just your everyday understanding.
Substantial word. Okay.
Yeah, that's right. But yeah, if you have a brain injury, it's very likely that you would be classed as disabled, but you would need a medical person to give a view on that. But I'll get to that.
And Hokman, you'd have to pay for that. You couldn't rely on the employer paying for that.
Well, you should be able. You should ask for an occupational health assessment,
Yeah.
and an employer should pay for that themselves. And again, I'm going to get to that when I apply the law to practically what might happen.
Thanks.
Okay, so right. So if you have a disability, that means you have a protected characteristic which affords protection, and it's illegal to discriminate against anyone just because of a disability. And discrimination includes direct and indirect discrimination, harassment, and victimization. Direct discrimination is usually quite obvious. It's just treating someone less favorably because of a disability. It's usually quite obvious. But it's indirect discrimination that's a bit less obvious. And indirect discrimination is when apparently everyone's treated the same, but a person with a disability, brain injury, is put at a disadvantage. So could anyone think of an example of indirect discrimination on someone who's got a brain injury? So when everyone's treated the same, but it's quite clear that the person with a brain injury is placed at a disadvantage compared to everyone else.
Could it be if someone was having like meetings on the first floor, but because of their disability, they weren't able to make the meetings?
Exactly. Yeah. Yeah, that's spot on. That's right. And actually, that has been the example of some case law actually that I've read about. But yeah, it's quite often, someone with a disability, like physical disability, yeah, it would exactly be that. It would be asking everyone, yeah, the meeting is on the first floor, so you have to go upstairs. Kind of like knowing that that person can't do it. But so that's a good example.
Does there have to be culpability in that sense? Do they have to be aware? Would you have to prove that your employer is aware
No,
of that?
no, you don't even have to prove it. They just have to prove that it's happened.
Okay,
Yeah.
thank
You
you.
just can't discriminate.
Yeah.
Yeah. And then harassment.
Before you go on this slide, what are the sanctions if you win your case against your employer under the Equality Act?
Oh, this is where I say I'm not an expert on
Okay.
on employment law issues.
Fair enough.
But I do know that sanctions could just be that you get money compensation.
Right.
Yeah.
Thank you.
Harassment, that's when there's unwanted or offensive behavior related to a person with a protected characteristic. So that could be, someone making fun of another person. And then victimization is when a person who's brought a complaint about discrimination or harassment is treated badly. So they're victimized for bringing it to everyone's attention or making a complaint. Okay, right. So I've talked about not being able to discriminate against someone because of a disability, because of a brain injury. But even within the law, there is an exemption to discrimination if it's a proportionate means to achieve a legitimate aim. So, if if the discrimination occurs because you have to maintain workplace health and safety or fulfilling a genuine essential need for the business, then the discrimination can be justified. So I know, could anyone think of how a discrimination might be justified?
I was thinking if a business relies mainly on the use of a car and someone isn't a car driver.
Yes.
Yeah.
That's right, exactly. So maybe because of your disability, suddenly you can't drive and you're the only driver. And so yeah, perhaps
Thanks.
yeah, that could apply. But yeah, it's good to be aware that sometimes there are exemptions to discrimination. under the Equality Act. Okay, right. So on to reasonable adjustments, which is what Simon mentioned earlier. So yes, I mean, if you have a disability, an employer is obliged to make reasonable adjustments to remove or reduce the disadvantage because of a disability. There's no set formula for what's reasonable. Much is going to depend on the circumstances of that case. You would have to you'd have to consider the requirements of the job, resources, and an individual's specific needs. So some reasonable adjustments could be, say, for instance, because of a brain injury, a person has physical issues, then maybe it might be reasonable to provide a one-handed keyboard or a supportive chair or other physical aids. For someone who's got cognitive issues, then it might be reasonable to provide to provide extra time to do work. It might be reasonable to provide a later start time, regular breaks, to work fewer days a week, or to have a quiet place for them to rest. If I put it out to everyone, can anyone think maybe from their own experience what sorts of reasonable adjustments they might?
Hog, Hokman. Now I'll put my reasonable adjustments. Well, because I had a company called Access to Work. I'm guessing you guys have heard of them as well, Hokman, haven't you? Access to Work.
Yeah,
Right. Now, what Access to Work did with me is they had the interview with me on a one-to-one, brought my line manager, right? And they also Access to Work do provide specialist equipment, like as you mentioned, people who's got one-hand operation, right, with specialist keyboards, mouses. If they've got issues with the back, they provide specialist chairs as well,
yeah,
right? And also in terms of travel, they also might find like taxis to and from work as well
yeah,
as shift patterns and stuff like that, and etc. I'm not going to go on to the whole list.
yes, yeah,
So that's what they did with me. So whatever I needed, well, they had discussed it, but the only disadvantage was, right, when the funding cost came through it, from Access to Work, they had to take the costing up to head office, and head office had to agree with what kind of equipment they could put into my workplace for me. So that's another criteria that the candidates might have to, or the employee might have to face as well.
yeah, exactly. Yeah, that's right.
You know, Hotman, it's really difficult to come up with what reasonable adjustments one could give. So in my case, being a lawyer, I'd lost the cognitive ability to understand the law and to be able to practice it. So I think
Yes,
it'd be very difficult to come up with a reasonable adjustment, which is partly the reason why I took voluntary redundancy
yes,
at the request of the firm, basically.
yeah, yeah, of course. Yeah, yeah, of course.
Mine changed hours wise. So I started later, did fewer hours across the week, and I did like about 2 hours on screen, and then I'd have half an hour break and do another
Yeah.
couple of hours. But I started very slowly from a couple of hours, a couple of times a week sort of thing, and then gradually built up to about 18, 20 hours a week. Then it was clear that that was all I could then manage.
And you've managed to maintain that, have you?
No, I got made redundant.
Oh, no.
It was down to funding and Brexit losing European funds and things.
So made
That
redundant
project
for
I was
other
on.
reasons.
So yeah, definitely.
Yeah. Okay.
Yeah.
And was that a good thing for you?
Yes, because looking back, I don't think I was managing well
No.
on those 20 hours compared to what level I did previously.
Makes sense.
Yeah. So yeah, of course. So everyone's very unique in this, and yeah. Okay, right. So let me carry on. Right. Okay. Now I'm going to apply some of what I've talked about into potentially what could happen in real life. So first, I'm going to look at the situation where, hold on, is this the right slide? Yes, it is. Okay, right. So yeah, I'm going to talk about the situation where a person is out of work and they are looking for work. Right. So in the interview stage, you wouldn't be obliged to disclose a disability, but you may wish to do so if you require reasonable adjustment during the interview process. During an interview, employers can only ask questions about a disability if it is about something essential to the job. But after an offer is made, an employer can ask any questions about a disability and health issues, and they can make the offer conditional upon those answers. And of course, once you start a job, an employer can't discriminate due to a disability. And again, I think it would be quite useful to hear about anyone's experiences of the job application process. Has
Hokman,
anyone been through it?
I'll put mine through before if anyone wants to jump in afterwards. What they did with me is I didn't mention my disability. Right. I went through two-stage interview. Because the first interview went successful, they called me back in for a second interview. Well, one was with the restaurant manager at the hotel firm I'm working at. Another one was with the line manager for the front office line manager, right? And after that, they gave me a successful job, and after that, they told me to fill in a PHQ. So what PHQ is a personal health questionnaire, right? On that personal health questionnaire, right, I had to declare my epilepsy.
Yeah.
Right, because if I mentioned epilepsy at the interview stage, I know where that was going to go. Me, getting substantial offering of a job, a suitable job, a confirmation of a job. Right, so I put that on the back burner until I got it, and then I filled in the PHQ.
Okay. Okay. Right. So if I go on. Okay, and now I'm going to talk about what happens when, say, a person is in work, they suffer a brain injury, they're on sick leave, and now they're looking to return to work. And actually, in some ways, this scenario would converge with, say, you were looking for work and then you've got a job. Right. So I guess one of the things someone who's on sick leave would have to think about is a return to work possible at that time? And of course, employers should resist putting pressure on people to come back before they're ready. And also, when an employee is returning, both sides should communicate and cooperate. Usually, what happens is when a person is thinking about returning to work, you have an occupational health report. So this is what Simon mentioned about who would pay for it. Usually, well, it would be the employer. They would pay for a professional to carry out an occupational health assessment, which will comment on disability, work suitability, and adjustments. I should note that an employee doesn't have to agree to an occupational health assessment, but if they do, the employee has the right to see an occupational health report before it's sent to the employer.
And if they don't, Hokman, does that mean they can't return to work?
Um, that I'm not sure actually. I mean, I don't know is the answer.
Okay.
I wouldn't have thought you would just have a blanket, not, that would just let a person not return to work outright. Yeah, but no, I mean, I'm not an employment specialist, so I can't really answer that.
Okay.
Yeah. Okay. Right. So, back to the occupational health assessment. Yeah. So, I mean, the outcome of an occupational health assessment could be that the injured person is unable to return to work. Uh, but if the report is that a person might be able to return to work. Employers are under a duty to consider alternative roles, and they can also um, um, consider any adjustments as well. But if you have a dispute with your employer, I would say go and seek advice from a proper employment solicitor, not just me. Yeah, and of course, if you are returning to work, there should be a back to work plan which sets everything out. So that might include a plan for a phased return, etc.
I think, Hokman, correct me if I'm wrong, I think there's a phrase RTW, return to work scheme. It's a phase where the candidate returns to work, states out what, like you mentioned on the slide, what he can't do, if there's any other roles in the department he or she
Yeah,
can take.
yeah, yeah, that right. That sounds about right. Okay, right, let's go to the slide. And now, right, so we do have a bit more time, and it seems like you guys aren't completely fed up of me yet. So I will talk about just a couple of case studies, just from what I've seen on how a brain injury might affect a person's employment. I hasten to add that my point of view is as a litigation solicitor. So typically, I'm with a client for the first 1 to 4 years after their brain injury. Right. So the first case study is Stephen. It's been that's not his name, of course. Stephen was a gardener. He suffered a severe brain injury in a car accident. He suffered very bad physical injuries and significant cognitive injuries. He made a very good physical recovery, but continued to have issues with his cognition. He agreed with his employer that he wouldn't be able to return to work. And luckily for Stephen, I was able to obtain funding for private rehab, and he had a case manager. He had an occupational therapist who assisted with trying to find work and the meaningful things to do with his time. Stephen started off with volunteer work at a charity garden. Then he looked into retraining to another industry. He was looking at retraining to the hospitality trade. Uh, uh, and at the last time that I saw him, he was exploring meaningful work to add purpose to his life. I mean, it wasn't clear that he would be able to return to paid employment. And the next case study is Geraldine. She had a high-flying position in finance, and then she had a stroke. Um, the stroke caused physical problems. She had weakness down one side of her body, but her cognitive functions were preserved. She was off work for 9 months in total. She was paid in full for 3 months. Then she had statutory sick pay for another 3 months, and then after that, she didn't receive anything. So she missed out on 3 months of pay completely. When she returned to work, she had an occupational health assessment, which recommended adjustments to her contracted hours. They recommended that she only work 9 to 5, also that she could have additional breaks and additional time to complete work. She was put on a phased return for 6 months. During this time, she would not undergo performance reviews, but unfortunately, after that phase return, she was put back onto the normal performance reviews, and she was consistently assessed as being below standard. And then unfortunately, a year and a half after returning, she was offered the option to leave or be put on a performance management plan. Geraldine shared with me that she got the feeling that her employer didn't like having someone who could only work their contracted hours, because they had this quite brutal work culture where everyone has to work really late and everyone has to be seen to work really hard, and they didn't like having someone who didn't fit that. So she was offered the choice to leave with 6 months pay, or to be put on a performance management plan. And Geraldine picked the option to leave with 6 months pay. Geraldine then left the job, and she's found a similar role with a much more sympathetic employer, and she's doing very well.
Right.
Good to
Good
hear.
news.
Yeah,
Good.
exactly. Yeah, that's right. That's right. Yeah. Yeah, just unfortunately, yeah, in her line of work, the culture was particularly brutal. Right. So, yes, you might be glad that we've reached the end now. And yeah, so yeah, I hope you found that useful, and of course, if you have any questions or anything, or indeed if you'd like to share anything from your own experience,
Um,
Some of it I
Hokman,
wish I'd known about before.
Yeah. I'll just
Um,
bring us all back, so I'll stop your let me check. Yeah, brilliant. Thanks so much, Hokman. That's wonderful.
I wish I'd
okay.
known more Hockman before I went back to work and went through the occupational therapy and some of the language they used in their conversations. And yeah, it was
Yeah,
a tricky time. And then I did end up on a performance plan.
yeah,
Had a new manager who was probably one of the worst I've had in 30, 40 years of working. Just couldn't communicate. And all I needed was for him to say in very black and white what he wanted me to do, because of cognitive issues meant I couldn't remember things and
yeah,
carry things forward. And that was so upsetting at the time, because I'd never had that.
mm,
And it was just a bit of a clash of personalities possibly as well. And yeah, it's a tough
yeah,
time.
yeah. It is tough. I mean, even with those protections, I think employees are very much at the mercy of their employers. It's not easy.
And you're
Yeah,
also coming to terms about your changes, because
yeah,
I've always been so very self-sufficient. So the one thing I should have done was had some kind of advocate or colleague or whatever in on
mm,
meetings with me.
yeah. Oh,
Thank you
did
so
they
much,
go?
Julie.
Yeah.
There are a couple of raised hands, Hokman. So go, pal. You've got a
Yes.
point to raise.
yeah, so Hokman, when you mentioned the UC one, right? Same as the PIP,
Yes.
there's two components to it. Right, and
Uh,
from what I know, if you hear me out, maybe you might agree with me or disagree with me. Right, the other two components is the LCA, which is the work capability assessment. I don't know if you heard of that one, where candidates must find work and then be assessed on it. And the other one is called the LCWRA, which is the limited capability work related activity, where the client or the employer or the candidate doesn't have to find work and they might get the highest rate. Like with PIP, you get 850. With the LCWR, it might be higher than what the other mean tested benefits are.
right. Yeah. I'm by no means an expert on
Mm,
universal credit or PIP, but I just thought
yeah,
I'd highlight it. But
sure.
it sounds like you've got more experience than I do with that. And
I
is
don't know.
that right?
I've heard it from a third party. That's what I'm saying.
Right. Okay.
Yeah, I've heard it. So I thought I just might put out to people who might consider going on it, and know the other two components on the UC as well.
Yeah. Yeah. But it's definitely worth noting that a PIP isn't means tested, and even if you're in work, and you're earning loads of money, you might still be entitled to PIP. So it's worth looking into. Yeah. And is it Adrian putting hands up?
Yeah, I had quite a number of kind of things that I raised, so I might as well just kind of read them up. So what about those of us who had a brain injury when we were too young to work? E.g., in my own case, at 1 month old, but only found out at 29 years and 7.5 months old. I'm 60 now, by the way. Much too late for compensation. What about exportable benefits? Would lose my DLA if I did any permitted work as a resident in Portugal since 2020, under the kind of rule that they have, which a group called British in Portugal was supposed to raise for me in a meeting with a minister, and not one of the issues that directly affected the person meant to raise these things, and she forgot, supposedly. So what about work in or online from countries other than the UK? As a dual citizen of Canada and the UK resident in Portugal, in my case, this means the Irish Republic, Canada, and Portugal. I mean, anybody who's a UK citizen can also work in the Irish Republic. And the reason why I can work in Portugal is residency, and Canada is because of my mother's Canadian and dual citizen. Then there are other grounds under the Universal Declaration of Human Rights and things which flow from it, various conventions and regional human rights instruments such as the ECHR, Conventions on Torture and Degrading Treatment, as well as the Domestic Human Rights Act. Now, the United Nations Convention on the Rights of Persons with Disabilities does not, unlike the Disability Discrimination Act and now the Equality Act, require you to have a condition or a kind of disability that lasts for at least a year. There's no time limit required, and also things that have been excluded from the DDA and the its successor, the Equality is Right, like for example glasses, wearing that. Everything counts under the UN Convention, and there is an optional protocol to apply it directly. And then there are also other acts, e.g. the Autism Act 2009, Acts on Deafness, etc. There's usually more and more of these coming in, which is kind of breaking up the Equality Act idea, which was to try and put it all under one roof. And the above acts will cover some people. Like I had an autism diagnosis in, when was it? 2000, year 2000, yeah. And also I note that employers tend to claim something else when it is actually disability. And I know I got an out of court settlement after hearing for directions with a tribunal, which I had to represent myself, for £550 for a mixture of disability, sex, and national origin discrimination. I was supported in preparing the case by the Disability Rights Commission, though not at the hearing for directions itself. Osteoporosis and social interaction were amongst the issues. And then a suggestion, try to join a trade union if you can, including their community branches for which you don't need to be in employment. Unite, for example, is one. And those are, my main comments. I have actually used, in terms of studying in Portugal, successfully the Anti-Torture Convention.
Wow.
To force adjustments to screens with the support of the relevant authority there. So,
is this what you've been through personally yourself?
Yeah.
Wow.
And I kind of realized, I mean, the problem with the UN thing is that they tend to boot things up to, sometimes the Human Rights Committee, and then you never hear about them ever again. It kind of gets buried in that way. So it's not actually kind of functioning the way it really should be. In my own case, I did some reporting on things which you can do, and just as a general thing. And they booted my thing up to the Human Rights Committee in, I can remember the date, February the 6th, 2017. Never heard of things since. And those kind of things have been the reason why successive American presidents, of course, Trump does it much more noisily, have said that, it's kind of not fit for the purpose, the whole UN human rights system, and that the Human Rights Committee is basically
Adrian,
obsessed with Israel and Palestine and nothing much else, which is largely true.
Adrian, you are fascinating. I mean, Adrian, where his mind goes is just amazing, Adrian. For all of your difficulties, you've got a brilliant mind. But right now we're just at the end, so I just wanted to make sure that we had enough time to thank Hokman for
Yes, of
his
course.
time today.
Yeah, I mean, maybe you could
Thank
just
you.
answer some of these questions kind of
Oh,
I think
over
it may
over by
be
email or
better
something.
if by email, if you could lay them out in an email, Adrian, I think
Well,
it would be
it's recorded in the chat, so
I
some
can
of the,
Oh, okay,
forward,
it's recorded
I
in
can
the
link
chat.
you to Hokman by email.
okay,
yeah, and then forwarded from the chat should be recorded, presumably.
Yeah, I can copy the comments in the chat to the email.
Yeah, that would be good.
Yeah, sure.
Oh, fantastic. That's good. Okay, well, Hokman, we're ever so grateful for your time and stimulating our neurons to connect by
Yeah.
learning new things
Brilliant.
In many
and
new ways.
laughing and looking to the future with hope that there are listeners out there that are working to help and defend people in their time of need.
Thank you so much.
Yeah, thank you so much, Hokman.
Yeah, thank you,
We'll
lot.
give him a round of applause.
Yeah.
thank you, everyone. Yeah, that was my pleasure. That was good fun.
Oh, good. Thank you.
Hokman, I was wondering.